chairman would do except to just work with those figures. I hold a slightly different view, and I think that position is grounded on a very narrow understanding of what verification means. Verification does not just mean and is not just confined to verifying the figures. Verification must also extend to verifying the authenticity of the forms. It is possible that once the figures have been put on Form 34A, those figures may fraudulently be altered. In circumstances where it would be difficult to tell whether they took place at the polling station or at the constituency tallying center. That is why we had security features in the forms. So that if you had Form 34As that did not have security features, one would even conclude that those were fake forms. And it would be inconceivable to expect that they would just be used, even though on the face of them, they look fake. And that's why authenticity
but that would be a big argument,
isn't
it? Because I've heard people say that the Court of Appeal decision, I think it was, what, 105, that it had, in a sense, limited the role, because otherwise what changed from what we used to have before, Joy?
And that is why, in the discussion we were having with Jotham, that was the point I was trying to make, that what the IEBC had done in releasing the information prior to the election was that the chairman was going to take responsibility for the tallying and verification. But then the matter came from court, and the court said, no, what comes from the constituency tallying center will be final. And even if there was a manifest error, it could only be overturned by a Supreme Court decision. Now, with that level of straitjacket, direct leading from the court, it would be inconceivable, therefore, for the chairman to decide, you know what, these ones don't make any sense, these ones don't make any sense. Now, as to the authenticity of the Form 34Bs and form that he was using to tally, now that is a question that even the court needs to scrutinize, because what are the circumstances that some had no serial numbers? Is there an adequate explanation? Which I imagine now, that might be something that's in the papers and the pleadings that I may not be too privy to. So let me not get into it. But I would imagine that even if something missed a security feature or whatnot, and now I'm coming from a point of not suspicion, but I'm giving people the benefit of doubt, they must have had an explanation why they accepted the same. And I'm hoping that in the papers, or because they had nothing in court to explain it away, but I'm hoping the papers, there's somewhere they've explained it. And if they have not, then we expect the judges to come back and tell us, look, there are these inconsistencies, and as far as we are concerned now, these ones are what would lead us to make this decision.
Okay.
Let me just add
briefly,
something on that.
so that we can move on.
Yes, what I'm saying is that verification means not just looking at the figures inside the forms. The verification entails confirming whether the forms are genuine. Number two, verification entails checking whether the figures put in Form 38Bs conform with the total aggregate number of votes in all the Form 34.
So can we agree?
So there is actually much more to verification.
So can we agree before we move on that this is perhaps one of those areas where the Supreme Court may need to come out clearly and establish this and say this is what that decision of the Court of Appeal actually meant? Because I think this is an argument that will continue for a long time, whatever the Supreme Court rules, if the court does not address itself to this and completely define what then the role of the different IEBC officers, because they all are IEBC officers at the different levels.
Yeah, but the court probably will, because Chairman Chebukati has been sued in his capacity as chair.
Yeah.
So there will be, I'm sure, a paragraph or two regarding what role he was expected to play and what he did, so that we can be able to marry the two and see, did he fit into the role as expected and defined by both statute and case law, or did he deviate, and whether that deviation, therefore, amounted to an irregularity, an illegality, or it was just an error. So those are some of the questions now you expect the court to bring a return on.
Okay, and we will talk about what the court did in 2013 and whether there are some things that we can talk about with regards to what is happening right now. And so just let's have a look at what the last week has really been in court from some of the things that happened there.
Case that using that formula, all you need to know is how many votes Prime Minister Raila has at any one time. And the votes of President Uhuru will come out automatically. And that you can demonstrate in court if you wish.
This petition is a science fiction, my lord. It's a science fiction which will only interest directors and actors in Hollywood if a proper scrutiny is carried out as the court has ordered. If everything available that the court has added to be availed to this court is brought before the court, your lordships and my ladies will find out that this election was a shambolic election.
So the wording is very, very clear. I read only with leave to copy.
As we said when we were responding to this application, the Commission has absolutely nothing right.
I submit that these petitioners, even by their own chief agent, have failed to tender any evidence sufficient at that level to overturn this election.
My lord, you cannot ignore the report in regard to the forms, and the forms are statutory forms. They are there to serve a purpose, and my lord, when you look at the report, and in fact, if at random you could be calling for some of those forms, you'd find that indeed we are justified in terms of the complaints that we're making.
First and foremost, my lords, the fallacy that many 34As were missing is untrue. All the 34As were used to generate 34Bs.
Something wrong has gone seriously with this entire process.
It is our submission that this report fortifies what we have said all along, that indeed this was a fair election where integrity of the vote was protected to the last, as far as humanly possible.
You people are going to sleep now. We don't have that luxury ourselves. We will deliver judgment on Friday. I can't tell you the exact time, but I mean, notice you will be notified by the registrar.
All right, so that wait continues, and some of the scenes, sights and sounds, if you like, of what was going on in the courts over the last couple of days. And ladies and gentlemen, this scrutiny that was ordered by the courts, of course, following an application by the petitioner, I want to understand in law where this fits, because we know there was a petition itself that was filed, all these responses. Then there was this other application for scrutiny. So in terms of how, in order of importance, how these whole processes typically play, was this a central issue in this, or was it just one of the fringe issues that might or might not make part of the conversation that the judges will be having as they retreat?
The petitioners had made a direct request to be able to access the IEBC system, because they needed to get information that only the IEBC was privy to, and they felt that that information was critical to proving or disproving their case. And therefore, for the courts to order for them to be given access for scrutiny was only just unfair. Because if you think about it, if I have evidence, if I need evidence, and only you have it, and you've refused to give it to me, then I go to a higher power to force you to give it to me.
But isn't that an interesting structure, Joy? If you think about the fact that the IEBC is also a party, they have been sued by this same person and saying, yeah, please give me evidence so that I can nail you. I mean, there's something there that
Because
just is mind-boggling for me.
The fact that the Supreme Court is sitting as a court of first instance and last instance, then it means if there is anything that should be brought to the attention of the court that for some reason cannot be brought to the reason of the court, for now, in such a case, you're on opposite sides, then the court comes in as an arbiter. Now, you saw how the court brought equality in that it's not just the petitioners who were given access. The respondents as well were able to gain access as much as they wanted as well. And also at the end of the day, the court sent their own certified experts as well as the ICT officer and the registrar of the Supreme Court to also generate a report. So the report that the court is relying on is not from either party. The court is relying on its own officers who looked at the same situation that the parties are looking at and therefore could be trusted to make a faithful report. So it's not a report that has been generated by Orengo on behalf of the ODM presidential candidate or generated by Fred Ngatia on behalf of the third respondent. This is a situation that the court says, let's go and look, but let's all look together. And what we find, then now let's come and...
It was quite interesting how they would find something and each of those people will have their own different responses to it. But Jotham,
exactly.
Yes. The drama that characterized this whole scrutiny issue, I found that intriguing, you know, where Paul Muite came and said, well, the people in Europe are still asleep, and then there was the whole thing of we are not able to copy and all of these things. How did that play out in your view, and where did that put IEBC? Because some people think the IEBC didn't look very good in the end.
Well, I also found it a bit unusual that there should be such a drama. It is expected that the information should have been made available. For me, I would want to look at it from the legal point of view. And I would want to say three things. Number one, election disputes are not like ordinary disputes between the disputants themselves. Election disputes involve the entire public. And so the power of the court in an election dispute is much more broad than in an ordinary dispute. And that is why the court is given that jurisdiction to order a scrutiny. Now, that then is a situation that enables the court to also gain information or the evidence on its own. And that then should be something that both parties should not only support, but assist. It is not a question of ODM getting evidence against, NASA getting evidence against IBC or any other party. It is the court being assisted to acquire all such other additional evidence as it may need to determine the case. And therefore, cooperation, ideally, should be given. And it should not be seen as if that information is being given to NASA. In fact, if it is true that the election was free, fair, and credible, then we would want to see IEBC taking the leading role in facilitating the procurement of that information. And especially when reasons are given that do not look on the face of them to be credible, it paints a very bad picture of IEBC because the impression created is that maybe there is something they wanted to hide.
I'll come back to what we probably, because I want us to look at the bits of the 2013 ruling so that we wind up on that note. But some people, okay, we can actually look at that and then we can have this discussion.
After extensive deliberations, we are happy to announce the Supreme Court has reached a unanimous decision on all the 4 issues that fell for the determination in presidential election petitions number 3, 4, and 5 as consolidated. The following is the unanimous decision of the court. 1, as to whether the presidential election held on March 4th, 2013 was conducted in a free, fair, transparent, and credible manner in compliance with the provisions of the Constitution and all relevant provisions of the law. It is the decision of the compliance with the Constitution and the law as to whether the third and fourth respondents were validly elected and declared as President-elect and Deputy President-elect of the Republic of Kenya, respectively. The above determinations, the following are orders of the court. Petition number 5 of the consolidated petitions is hereby dismissed. Petition number 4 of the consolidated petitions is hereby dismissed. As to petition number 3 of the consolidated petitions, the prayer by the petitioners seeking a declaration of recomputation of percentages by the second respondent is declined, as the court has no jurisdiction. Regarding orders as to costs, the court orders that each party bears his, her, its own costs.
All right. Justice Willie Mutunga there of the time giving that ruling that has been widely criticized around legal circles and I think even generally. So I'll put this question to each of you. Regardless of what the judges rule on Friday, what specific improvements would you like to see, Joy, in terms of the quality of their ruling when they give it on Friday?
The fact that the Supreme Court is the only arbiter in a presidential petition means, therefore, that moving forward, the jurisdiction on how to handle election petitions can only be developed in the Supreme Court. Now, the decision in 2013 had some places where it helped, because that's why we've been able to see a reform of the electoral law and the election rules, and even some of the things that we're talking about now. For example, these rules about depositing the forms. When IBC is done with the forms for the presidential election, go deposit them in court, because it's all in anticipation for what is going to come out if there is a petition. Now, those are things we saw from the failings of 2013. Another thing in 2013 that left us a little bit perturbed is, just as the Chief Justice has read, that they gave the very brief ruling that the general public heard, but now the lawyers had to wait for the next 14 days to be able to read the reasoned ruling. Now, for many Kenyans, they'll be telling you they don't want a 1-minute judgment, because... No,
I mean, because just says petition number whatever dismissed. Exactly. We don't even know what that is.
And you see now, the law allows them...
So that's something you would like to
see change? The law allows them to do that.
Because I want to go to just...
Yes, the law allows them to do that. But what I would hope is, even if they're giving us an abridged version, it would have a little bit more flesh on it, rather than just this line dismissed, wait for 14 days, then you'll see how we reasoned in the matter.
Just in 2 minutes, perhaps less.
In terms of what I would like to see improved upon, number one, I would like to see a jurisprudential development on various areas. I would want to see a very thorough discussion on the question of who bears the burden of proof and how you should bear a burden with regards to information that you have no access to. I think that is something that should be thoroughly considered. Number two is the standard. There was a lot of argument as to whether the standard is beyond reasonable doubt or on the balance of probabilities. Now, this is a point where various countries have taken different positions. And I think ours also...
But ours was apparently something
it's somewhere in between. And I think it needs to be made much clearer for going into the future. Number three, I would like to see a very serious consideration on the constitutionality of Section 83 of the Elections Act. That is where the provision that says that no election will be invalidated if it is found that it was substantially in compliance with the Constitution and the relevant law, or if the non-compliance does not affect the result. Because the provision as it is currently framed would appear to allow a constitutional infraction. And it is not possible for an act of parliament to justify a constitutional breach. Number four, I would also expect that
And you have 15 seconds, Jotham.
Precisely. What affect the result should be defined with clarity. What exactly do we mean affect the result? Okay. Are we talking about what affect the actual count, or are we talking about what affect who would be winner? If the results prevented my people from voting, is that something that affect the result? These are some of the areas that I would like to see the Supreme Court pronounce itself more boldly.
All right. Thank you very much, Jotham Marua, Joy Brenda Mudivo. Always a pleasure to have you. That's been the Supreme Petition. Remember, we are still covering for you this. The news update is coming up in a short while, but we'll be here every night, including Friday night, to just look at exactly what the judges will have determined. From now, good night.
The burden of proof is the duty placed upon a party to prove or disapprove a disputed fact in court. The burden of proof determines which party is responsible for putting forth evidence and the level of evidence they must provide in order to prevail in their claim.
This is KTN News.